matter before the court is Cumberland 23-124, Angela Smith versus John Henson et al. We are being streamed live on the web, both by video and by audio. So I would ask counsel to come to the podium to identify yourselves by saying your names for the record together with the party that you represent, starting with the appellant.
Christopher Taintor for the appellants John Henson, MD, Mercy Hospital, and Eastern Maine Healthcare Systems.
Thank you.
Alicia Curtis for appellees, Angela Smith and Richard Smith as personal representatives of the estate of Peter Smith.
Thank you. Counsel, if you're ready to proceed, we'd be happy to hear your argument, Mr. Taintor.
Thank you, Your Honor. Chief Justice Stanfill, and may it please the court, my name is Christopher Taintor. I'm here representing the appellants, Dr. Henson, Mercy Hospital, and Eastern Maine Healthcare Systems in their appeal from part of a judgment entered in the Superior Court after a jury trial. The fundamental issue, at a very basic level, the threshold issue that's before the court is one the court grapples with frequently, and that is simply the question of how we determine whether a statute is ambiguous and what the consequences are of finding ambiguity in a statute. As the court is aware, ambiguity can arise in a variety of ways. It can arise from the fact that individual words have more than one possible meaning. It can also arise from the context in which the words appear, their juxtaposition with other words and sentences in the same statute, and even the role they fulfill within the statutory framework as a whole. We argue on this appeal that the Superior Court made a fundamental legal error in concluding that the 2009 version of the Wrongful Death Act, and particularly the provision that the jury may give damages as it determines a fair and just compensation with reference to the pecuniary injuries resulting from the death, was ambiguous. It was unambiguous. That's where the court erred. That phrase, that sentence, those 23 words are ambiguous both linguistically and within the structure of the Wrongful Death Act as a whole. The primary source of the ambiguity, I would submit, lies in the terms compensation and injuries. The concept of compensation connotes making someone whole, and the concept and the term injury connotes the existence of a person, a victim, who's been harmed by a defendant's conduct. That is, in our view, completely consistent with black letter tort law as set forth in the Restatement Second of Torts, which defines an injury as the invasion of any legally protected interest of another. And it's consistent with what this court said in Bernier versus Raymark Industries was the fundamental objective of tort law, which is the compensation of victims who have suffered. We believe it was legal error for the Superior Court to reject out of hand the defendant's contention below that the plaintiffs were entitled to recover only if they could establish that they were harmed financially by their son's tragic death. And it was error for the court to conclude that the term pecuniary injury unambiguously encompassed the economic effect of a death.
Counsel, if I could interrupt,
Sure.
if the green light is on. Are you saying that those 23 words are ambiguous or unambiguous?
I'm saying they're ambiguous.
You think they're ambiguous?
Yes.
But you just noted that compensation has a defined meaning.
Right.
Pecuniary injury has a defined meaning. And read in the context of the statute above it, it says, except as otherwise provided, the amounts recovered are for the exclusive benefit of the individuals who are then described. How is that ambiguous?
I think the ambiguity arises from the point made by the appellees below and in their brief in the law court, which is that in their view, and I think in the view of the Superior Court, there's a sharp distinction, and there needs to be a clear separation between the concept of who can recover, to whom damages are distributed, and how those damages are calculated.
Right. So you want to go then to the 2009 amendment? Is that where-
Clearly,
is that
that's
where-
the-
that's where you're heading?
That's the statute that was in effect at the time of this young man's death, yes.
So in that regard, the clear purpose of that Representative Dill had in mind in introducing that statute was, that bill was twofold, to raise the cap on punitives
Right.
and to alter the way that damages are measured with respect to pecuniary injury, correct?
Correct.
The bill was amended by Committee Amendment A.
Correct.
Committee Amendment A did two things. It altered the cap for punitives, and it deleted Section 2. Section 2 was focused on a different statute, the survival statute, not the wrongful death statute. It left intact, though, the deletion or the excisement of the key language that's in issue here. Now, given that it was Representative Dill's chief objective to change the manner of computing those damages, and given the fact that the Committee Amendment A did not delete that language that was excised, did not make a change, did not restore that language, didn't the 2009 amendment accomplish what Representative Dill set out to do?
I would argue that it does not. and
Why?
It did
Why?
not because it's very clear that Representative Dill talked about her bill as having two parts. Part one was the raising the cap on punitive damages. Part two was altering the way pecuniary damages are calculated. That was clear at page 30 of our statement of supplement of legal authorities in Representative Dill's own words. It's clear in the public hearing ceremony, public hearings summary, from the Office of Policy and Legal Analysis, which appears at page 31 of the supplement of legal authorities, where the Office of Policy and Legal Analysis said, Section 2 of the bill amends the provision of the probate code that provides that causes of action generally continue despite the death of either party. And then at page 34 of the supplement of legal authorities, the committee said, the amendment deletes Section 2 of the bill, which specified that claims for pecuniary losses are lost by the death of either party.
Right,
Now,
but Section 2 pertained only to the survival statute. And if that had stayed in the bill, wouldn't there have been an internal inconsistency? Because it would have created, in effect, a cause of action for the estate, which would have been in conflict with the wrongful death cause of action for the survivors.
Well, I think that first of all, I think that the way the bill was phrased and structured was awkward at best. I don't think that there was any need to amend the Wrongful Death Act or amend the law in any way to provide that a cause of action survive the death of a victim, because that result already existed, as you point out, in the survival statute.
Well, but no cause of action for a loss of future earnings has ever survived the death of the victim. I mean, we haven't, other than for the benefit of the beneficiaries, but I mean, it didn't independently, it wasn't a survival to the estate prior to this amendment.
Correct. The only cause of action that existed or can exist under the survival statute is a claim for injuries that accrued prior to the death. So,
But isn't that the intent then of this, by eliminating the phrase that was eliminated? Isn't that really indicating that the pecuniary loss actually will go to the estate and apparently is recoverable by the estate to the lost income or future earnings of the victim?
well, the The difficulty with that, I think, is that there is no, in a situation where we're talking about income that would have been earned after the death of a victim, there is no injury. There's nothing to compensate because the person who would have earned that income is no longer alive.
And you're basing that really on sort of the general idea of what an injury or loss is, that there has to be somebody who suffers that injury or loss.
Correct.
But by eliminating the language about for the benefit of a certain class of people, and we can argue about who that class could or should be, but by eliminating that language, isn't the legislature actually saying, go ahead, that we're going to eliminate that part of the analysis of what the pecuniary loss is? In other words, that it is the lost earnings without regard to whether it was for the benefit or for a dependent in any way.
I guess the difficulty that I see, Your Honor, is that, again, arises from the awkwardness of the bill itself. It was
We can all agree it was less than perfect.
Representative Dill characterized it as essentially creating a surviving cause of action. But that really wasn't what her initial intention was. Her intention was, in Section 2 of her bill, to create this new claim that existed on behalf of the beneficiaries.
No, her intention, according to her testimony, was, she says, the question raised by this bill is whether the economic loss should be determined solely by who survives
Right.
or upon the economic loss to the estate due to the wrongful death.
But your position is there is no economic loss to the estate on
Right.
account of the death.
Right. And again, I think the legislative history is garbled and confusing, and I think the difficulty is that throughout all of the discussion, whether it's by Representative Dill, whether it's by the committee, whether it's by the Office of Policy Analysis, all talks about two parts of the bill. One, the punitive damage piece, one, changing the way we calculate pecuniary loss. And it's clear that the committee said, we're getting rid of Section 2. We don't want Section 2. All we want to do is change the change the punitive damage cap.
Then why didn't they restore the language above?
I don't think there's a good answer to that, Your Honor. I think that's poor draftsmanship.
Then why didn't they correct that in the years subsequent when they made other amendments to that section?
It hasn't been raised, as far as I can tell, in the legislature,
Were
Your Honor.
people aware of the consequences? I mean, Senator Cates testified at one point, making the previous assumption and not to this. Were people aware of the fact that this tectonic change had occurred?
Apparently not.
But it really has been raised. I mean, we have the Fitzpatrick and Cohen decision from federal court. I understand it's not a law court decision, but I mean, there have been, although we haven't decided the issue, there definitely have been blips out there saying, well, it means now that the estate can recover pecuniary injuries without proving loss to the beneficiary.
And I see my time is up, but
sorry.
if I may add,
You may.
we also have your decision where you, I think, more recently said in the Superior Court that pecuniary damages are essentially, and I'm paraphrasing, obviously, measured by potential benefit or the loss of benefit to the survivors.
I think I said a pecuniary injury refers to lost economic benefit which the decedent might have reasonably provided to the beneficiaries.
You quoted it accurately. Thank you.
Attorney Curtis, we're happy to hear your argument.
Chief Justice and Justices of the Court, may it please the Court. Maine's Wrongful Death Act resolves a fundamental problem that existed in the common law before 1891. Without the act, when Peter Smith died on July 2nd, 2017, any action for his death died with him because according to the common law, Peter Smith had no damages that survived his death and no legal standing. The act solves that problem in subsection A by making the tortfeasor liable for damages notwithstanding the death, quote unquote. In other words, the tortfeasor is liable for the same type of damages as if Peter Smith had been injured but lived, as modified by subsection B, which spells out the categories of damages, the measure of damages, and the distribution. The statute is in derogation of the common law and should be strictly interpreted and applied. The plain language of the statute controls, not principles of court law, and the plain language is unambiguous. In 2009, when the Maine legislature struck the clause in subsection B, measuring pecuniary injury as damages to the persons for whose benefit the action is brought, it struck the loss to survivors scheme. And appellants raise an ambiguity in the definition of an injury, but the restatement second of torts, section 7, distinguishes between a harm, which is a loss in fact to a particular person, and an injury, which is the invasion of a legally protected interest. The Wrongful Death Act created a legally protected interest in the death of Peter Smith, and that is the injury here. If striking that clause had no legal effect, then keeping the clause would also have no legal effect when the legislature chose to keep it as to loss of consortium benefits. This court has held that a statute cannot, all words in a statute must be given meaning, and none can be read as meaningless surplusage. Since 2009, there have been 3 decisions: Cole v. Holland, Fitzpatrick v. Cohen, and the trial court's published opinion in this case. All interpreted the 2009 amendment to remove the requirement that pecuniary loss is tied to a particular beneficiary's loss. Since 2009, there have been 5 different amendments to the Act, one since the 2022 published decision in this case. The legislature never reinserted the operative language it deleted in 2009, and appellants were, in fact, aware of the consequences of the change in language, because if you look on pages 31 to 32 of appellants' legal authorities, the public hearing summary, you will see that the opponents testified that this act would represent, that the bill would represent a substantial change. The Wrongful Death Act has always been just for the spouse and minor children. Most of us don't have expectations in our siblings' earnings, and that this would represent a big change with big payouts possible. So appellants were certainly aware of the change at the time of this bill and have probably been aware during the 5 subsequent legislative sessions. I waive the rest of my time.
I think your time is actually, we're into the green. I was about to nudge the clerk. I actually can see the timer. Here's what I struggle with here. Pecuniary loss or pecuniary injury as used in the wrongful death statute in Maine is really a term of art that has encompassed a whole concept of what it means to be a pecuniary injury, and it has been measured always by the loss to the beneficiaries or to his dependents, whoever they may be, whether they are statutorily, who should be recognized as a statutorily recognized beneficiary. In that language, that term of art of pecuniary injuries was not changed, and that's how we've always defined it.
But if you read subsection B in conjunction with subsection A is what awards damages notwithstanding the decedent's death. So then that awards damages as if Peter Smith had survived. If he had been harmed but not killed, he would be able to recover for lost future earnings. Subsection A awards those damages, and then subsection B modifies them. When that limiting language was struck from subsection B, you then revert to subsection A. And if you look at similar statutes like New Hampshire's statute, it has a similar construct where it's also a loss to a state scheme, and it's also awarding damages as if the decedent had lived.
Similar construct, but the language is very different, right? It's much clearer in some of those other statutes.
The question, they could do it, in other words. The question is whether they did do it.
Right.
That there was argument in front of the legislature at the time that this would be a big change. And it would, because it's increasing damages. So why was there no fiscal note?
The fiscal impact is simply to the tortfeasor. I don't think there's ever been a fiscal note about fiscal impact to the tortfeasor.
But following on a similar point, I mean, this is a tectonic shift for our policy dating back more than a century, was to benefit the folks who would have relied upon the decedent for their income. They've suffered an injury. But this shifts it and basically says the decedent would have made this money, and this money he would have earned goes to the estate for distribution, even though the folks who would be distributed didn't necessarily have any economic injury. And I was following the chief's comments there. I mean, our law on awarding of injuries for damages requires a causal connection, proximate cause between what happened and the harm that occurred. And if this changes as you propose here today, constitutes a major shift from that. There is an award of damages based upon future earnings that's being given to somebody who didn't suffer any harm. It goes to the estate. It gets filtered out through folks who obviously are happy to receive the income, but they never would have had the support from the guy had he lived. So I'm getting a long time getting to the point, which is, with such a huge tectonic change that apparently escaped the attention of some folks but not others, wouldn't it be clearer in the statute? How could it be done in something that parties consider to be ambiguous? I realize you don't think it's ambiguous, but some folks do, which probably is the definition of ambiguous. So a long prelude to a simple question: wouldn't this have been written out much more clearly if this is what actually occurred?
To be clear, Justice Mead, appellees are not advocating for this change. This is a change that the legislature made. This is a change that 3 different decisions by different courts have interpreted to mean a shift to a loss to a state. And appellees are simply upholding the unambiguous construction of the statute. Certainly, the statute could have spelled it out in a more crystal clear way, but there are many statutes that could be more crystal clear. The fact that it's not as fulsome as it could have been, the fact that it doesn't include as much detail as it could have been, does not make it ambiguous.
What effect is there from the legislature's decision to amend the bill to delete what was Section 2 of LD 428?
Section 2, the Judiciary Committee was wise to delete Section 2 of the bill, LD 428, because it represented a redundancy. It represented a redundancy that you now see actually in the conscious pain and suffering damages, which is it would have referenced pecuniary injuries in the survival action, and then they would have been referenced again in the Wrongful Death Act, potentially leading to a double recovery.
Well, would the damages have gone to different places? In other words,
That's an issue right now with loss and consortium, and if you read the trial transcript below, there's actually a colloquy between counsel and the court about the need to be careful between the attorneys and the trial court that there's not a double recovery of damages for loss of conscious pain and suffering. So referencing pecuniary damages in both the Survival Act and the Wrongful Death Act would have created problems. The judiciary was wise to delete that, but the deletion of that says nothing about the shift from a loss to beneficiary scheme to a loss to the estate scheme.
What the intent underlying the 2009 legislation is clear from what's contained in Representative Dill's testimony, but I'm not sure that the change made, deleting the reference to, quote, to the persons for whose benefit the action is brought, unquote, was a meaningful change. In other words, under the historical interpretation of that was the people who are financially dependent upon the decedent, and the intent was to change it to whoever else, for whomever else the benefit was brought. But for example, the plaintiffs in this case, the action was brought for their benefit, wasn't it? So did deleting that phrase really change anything?
I have 2 comments. First, if deletion of that clause was meaningless, then retaining that clause in reference to loss of consortium damages would also be meaningless. That would be meaningless in reference to loss of consortium damages, which are for the benefit of those for whom the action is brought. And so this court cannot read language in a statute to be surplusage. That's what appellants are asking this court to do. They're asking this court to read a clause that was retained in the statute as surplusage and meaningless. Additionally, the legislative history since the 2009 amendment shows the legislature has actually intended to decouple the idea of recovery from dependency. So historically, the Wrongful Death Act gave priority to the surviving spouse and to minor children. You see in the 2019 change, you see that removed. It's simply the distribution, the scheme for distribution simply tracks the probate court. If the current act actually applied today, if Peter Smith had died with a spouse and minor children, his parents would still be or if he had died with a spouse but without minor children, his parents would still be a wrongful death beneficiary. Why? Because the act now has decoupled the concept of dependency from the status of being a wrongful death beneficiary.
Can we use subsequent legislative changes to assume what the intent was of a prior legislature?
Appellees take the position that there's really no need to look at legislative intent at all because the statute is ambiguous. Certainly you can't say that it's a clear statement of intent, but it shows the progression of the legislature's thinking as to the Wrongful Death Act. And certainly it shows that given that there have been 5 subsequent amendments and appellants and amici never brought the policy arguments that they're bringing here to this court to the legislature, and the legislature never corrected what appellants contend is a mistake by reinserting language, I think that's clear that the legislature intended to do what it did.
That might be because they thought they had prevailed back in 2009 when Section 2 was deleted. Right?
After that's possible, but I think after the Fitzgerald v. Cohen decision, they could no longer think they had prevailed.
There don't appear to be additional questions unless we have anything further.
Nothing further. Thank you, Your Honor.
Thank you, counsel. And Mr. Taintor.
Thank you. I'll be very brief. Attorney Curtis said sort of early on in her argument, and I'm paraphrasing, I'll do the best I can, that we don't need to look at sort of background principles of tort law when interpreting the Wrongful Death Act. And I submit that that is completely out of step with what this court has always done, which is to interpret statutes with reference to tort principles or other legal principles that exist in the law.
But wrongful death is a creature of statute, totally created by the legislature. We only interpret what the legislature meant.
Well, yes, but it sounds like a,
I'd like to know what you think it sounds like.
yes, but in the case, that Justice Stanfield decided, the Coughlin versus Peterkin case, it's interesting, one of the things that she had to do was to deal with the question of whether the plaintiff in that case had a bystander cause of action. And the Wrongful Death Act itself, all it says about emotional distress.
So you're saying tort principles overlie
Exactly.
the application of the statute. Can I ask you a question? I believe it was suggested that there's been a trajectory of policy change on this subject in the legislature, and that if the case went to trial today, it would be in a state-based case. But we can look at I'll ask you first if you agree with that, but secondly, if that's the case, can we look at that trajectory of the legislature increasingly leaning to that interpretation?
I think that is I don't think, honestly, that methodology helps interpret the 2009 statute. What I can say is that we still need to, or any court still needs to, when trying a wrongful death case, determine whether there's sufficient evidence to support a claim for pecuniary loss or any other kind of damage. And so regardless of who the beneficiaries are, as Attorney Curtis said, it could now be Peter Smith's hypothetical wife and his parents all being beneficiaries. There would still need to be evidence presented to the court or to a jury to show that those individuals were harmed economically by his death.
Can I switch it back to the language of the statute and make sure I think I understand what the crux of the argument may be here? That the wrongful death statute, and if people are still going to have questions, I'll give you time. The wrongful death statute, is it a matter of whether we interpret which clause was modifying what? In other words, it really basically said the jury may give damages. And then it says for such pecuniary injuries. And so the clause that was eliminated, is it a question of whether that meant the jury may give damages to persons who were, for whose benefit the action is brought? Or is it really pecuniary injuries to the persons for whose benefit the action is brought? Is that the difference?
Well, honestly, that's not the difference that we've focused on in the argument, but I think that's an important point that's kind of been glossed over by everybody, because I think one completely rational way to read this is to say that the missing words described only who would be the recipients of the damages that the
Right,
jury
and so it
could
seems to
give.
me you're essentially saying that the original statute meant the jury may give damages to the person for whom, and so now they give it to the estate instead. And, but it doesn't change how we measure it.
Right.
And that what they're saying is, no, the statute measured pecuniary injuries by saying injuries to the persons for whom, and that by eliminating that phrase, they no longer are limited as being injuries to the persons for whom the action is brought.
Right. I think that frankly is a distinction that's been lost in all the argument here, but it's an important one. I think one, again, lending further ambiguity to the statute, one question really is which term that now deleted phrase modified. And if it simply meant that damages would be, the jury could give damages to the persons for whom on whose behalf the action was brought, that is kind of surplusage or redundant, because we already know from the first sentence of Section 2804B that they are the sole beneficiaries of any award, whether it be for pecuniary damage or anything else, except for funeral and medical expenses.
Okay, and did you have a question, Justice Horton?
I did.
I said we're going to go, we're ramming right through the intersection here.
Thank you for indulging me. The statute refers to surviving spouses, minor children, et cetera, and there's no issue about those people possibly needing support from the decedent and suffering a pecuniary loss. But it also refers to heirs, which is the situation in this case, as I understand it. And are you saying that if the decedent's will mentions nieces and nephews or charities or whatever, those people all have to come forward and prove that they actually were supported by the defendant, the decedent in some fashion?
Well, I don't think this has anything to do with the will. Although, I mean, I think when the legislature talks about the heirs now, they're talking about heirs under the intestacy provisions of the probate code. But I do agree with you that anyone who is an heir under the intestacy provision, I shouldn't say I agree with you. Our position is that anyone who it would be considered an heir under the intestacy provisions of the code must prove his or her damages.
You think they do?
Yes.
Okay. All right.
I see my time is up.
Thank you, counsel.
Thank you.
And our,
Any chance to respond at all?
If you would like.
Well, I think we should see if they
well,
want to say
my
anything.
colleague wants to give Ms. Curtis a minute
Well,
to
only if,
respond.
since we've run way over, I just thought.
which is that the Wrongful Death Act measures the pecuniary damages as a loss to the estate, but it distributes them to the wrongful death beneficiaries. And that's clearly in the language of the act, which says that unless otherwise stated, it's distributed to the wrongful death beneficiaries.
Thank you. And counsel, thank you for the arguments and the briefs. The briefs were really very, very helpful, as was the argument, as evidenced by the fact that we decided to run, or, quite over the time for these issues. So thank you. We will, as our usual practice, take the matter under advisement and issue a written decision in due course. And with that, I think we're in recess for the term.